Hey, everybody. We're always give enough time at the front to let all the participants get into the webinar. So we're going to talk amongst ourselves, and I'll let you know when we're about to start. And drink liquids. I don't know, Eric. I think, look at this, orange. Ben did a great job on these. So.
I like it that I just messed up my camera. Oh, there we are. That's okay. People don't really want to see me anyway.
It's all about the words. Look at this, losing my voice again already at the start. I'm allergic to you guys.
That's hurtful. It's deeply, deeply hurtful.
Okay. I can't believe it. Once again, we're about to start and I've completely lost my voice. If I can't get through these things, I'm just going to go, hey guys, it's all you. Hey, I think we're going to jump in here and start. So, hey, good afternoon, everyone. I'm Neal Kent. I'm the Senior Consultant for Contact Center Compliance and the host of the webinars and summits. I help clients successfully navigate the complexities of marketing regulation. And in that, quite often we've found that companies are striving to comply, but they're really getting consent wrong. And consent, I quipped with Eric on our last Masterclass is that TCPA now should stand for Total Consent Protects All. And so to that, in helping everybody try to navigate consent as a very critical component, we bring through and try to make these master classes to help you better understand and create best practices. To that, a little housekeeping. We're not practicing law today, except you have some of the best attorneys on the planet. So ask questions. Use the Q&A tab. Daniel is generally there firing off answers. We also have marketing at dnc.com. If you're not comfortable putting up a public message, our producer is monitoring that and he will flash that question back to the panel. Marketing at dnc.com. Quick note, we're proud to announce that the summits are back. We will be having this year the Masterclass workshop, and it's going to be live and in person in Florida on December 6th and 7th. Eric, I think you are our keynote, you're going to be there. So that's going to be absolutely awesome, right? Also, for the attendees of our Masterclass webinars, there will be special promotional pricing. You'll see sort of a link and a code at the end of the webinar. So look forward to that. We look forward to seeing you in Florida. Now, it's my pleasure to introduce our expert panel. By the way, this is always my favorite group. Our chair today, leading off a little bit different, is Puja Amin. Puja is the corporate counsel who oversees marketing, compliance, and litigation defense for one of the nation's most highly regarded mortgage originators, LoanDepot. But from expertise, before she went to the corporate side, she was part of Eric's team. And really has tremendous expertise in financial matters and TCPA litigation. Now in the second chair, which is unusual for me, is Eric Troutman. Eric, of course, is partner at Squire, Patton, and Boggs, and he is one of the country's most prominent class action defense lawyers, and he's a nationally TCPA recognized litigation expert. He has served over 250 cases lead, and you've litigated way over 1,000. I don't think anybody else comes close to that. In fact, before this session, he just came onto here. He had a suit and tie. He was in federal court today, defending, trying to keep you guys from trouble here. His website is required reading, www.tcpaworld.com. And actually, I agree with you, Eric. It should be a lifestyle if you're marketing. And really cool with us today is also Daniel. And Daniel is a litigator in the Atlanta office of Squire, Patton, Boggs, and one of the most brilliant defense strategists that I've had the pleasure of dealing with. He is really, once again, also a true expert. And just to keep with the nomenclature, this particular group actually has titles. Eric's the Czar, Puja is Queenie, and Daniel, the Archduke, and I guess that makes me the court jester. I don't know. Anyway, in all seriousness, let's move on and begin to jump into the session. And with that, Brian, you want to load up the slide deck? And Puja, I'm going to let you take it away.
All right, folks. So we all know, and Eric can talk more about this as he often does, that TCPA is the largest cash cow in American history. And this is why you are joining our webinar today. We understand that it can result in millions and millions of exposure. We have 4-year statute of limitations. And, as most recently we heard on TCPAWorld.com, NCLC just got 1.7 million from a TCPA judgment, which is just ridiculous. So we're here today to tell you how to protect yourself. And so you understand that, the lead generation industry shouldn't just be a shield against compliance. It should also be, a shield against litigation, but it should also help with your brand protection. We're here to tell you today how you can do that.
So can I just jump in real quick, Puja? Thanks for setting it up. But this NCLC thing, I have not had a chance yet to talk about it on TCPAWorld.com. There's like some kind of procedural wrinkles that have prevented me from blogging this. But so the NCLC, for those of you that don't know, they're an advocacy group, right? They're supposed to represent like poor people and consumers. But what they really have been spending their time on recently is convincing Congress to keep the TCPA really, really broad, and convincing the FCC to deny a bunch of really common sense reforms to the TCPA. And the reason they're doing this is because they're literally, this nonprofit group just collected $1.7 million from a TCPA judgment for what's called a cypre payment, which means like money that wasn't collected from the folks that actually got hurt. It was just left out there. And so it was given $1.7 million to this company, this organization, this, I guess it's a nonprofit, allegedly, that does nothing essentially but advocate for more lawsuits and litigation. It's a horrible thing. So if you ever end up sued, make sure that you fight tooth and nail to not ever let the NCLC be your cypre recipient. They should never get $1 from live TCPA litigation. That's just my 2 cents. But as Puja just laid out, of course, the TCPA is and was and remains the biggest cash cow from a litigation perspective in history. All the abusive litigation you've heard about out there, all the archetypical plaintiffs' lawyers driving their yachts and their airplanes and their Rolls Royces, nothing has padded their pockets more in history than the TCPA. So that's certainly one really big reason to keep all of this stuff in mind, especially when you're buying leads, which, by the way, let me just kind of lead with this. Lead buyers are absolutely in the crosshairs right now, absolutely in the crosshairs. And just because Facebook was decided favorably for callers does not mean that you're safe because of the DNC rules, which we're going to talk about a lot today. So pay careful attention. I know you're here because you know all of that, but worth kind of framing the issue. And Puja, you have to deal with me because I'm going to be just yapping the whole time. You just got to be like, Eric, I've had enough of you. Be quiet.
Just need to learn how that mute button works.
All right, so let's go to the next slide because what we really need to talk about, though, is less exposure and more brand protection, as you were teeing up, Puja.
Yeah, so, like I said, more importantly than shield against litigation is respecting and honoring consumer protection principles to ensure a positive brand image and customer experience. We see the recent changes in the government regulatories, folks like the NCLC, what are they really after, right? Other than the dollar and what the plaintiffs' attorneys are after, but they really want to see companies protect their brand and protect the consumers. So you want to disclose clearly to consumers who you are, how you'll share their information before reaching out to them. Leads should be viewed as consumers who are potentially interested in your product or service. So if you're selling car insurance, don't buy leads from lead partners who are generating leads for folks who want to purchase a mortgage, for instance. It's not right, and it can really ruin your brand. Just if you keep that in mind, common sense approach, knowing that's all about the consumers, you're on the right track.
And just to echo that, it's critical for everyone, especially post Facebook, right? I mean, I get called all the time, and it's interesting how quickly the calls have changed, right? When I first started fielding calls, it was, I'm not comfortable. I don't think we're really going to change our processes. It's too much meat left on the bone, and we're not exactly sure what Facebook really says. And slowly, but really not that slowly, it has crept to, well, Facebook gives us an open book, so now we can be more aggressive. And the principles that Puja just laid out, even if from a liability standpoint, there's some truth to that, you need to deploy any consentless contact strategy, either to a landline or to a cell phone, keeping the consumer experience first in mind, because you will tarnish and destroy your brand and the partnerships that you have with folks that are buying your leads, or that you are assisting to sell products. Their brands are going to be destroyed as well if you're not cautious. Now, Facebook does open up some opportunity where you're doing a contact outreach that is pro-consumer, that won't hurt your brand, where the TCPA previously was kind of a ticky-tack, wet blanket that didn't let you do something that was really good for the consumer. But you got to pick and choose those spots, and everyone listening, as Puja was just saying, you really ought to think of this less as a compliance issue and more as a brand protection issue.
We'll touch on it later, but that comes down to defining your standards and really conveying those to your lead partners, regardless of what case law is coming out or what Facebook says or doesn't say. You got to stick with your own brand standards.
All right, so let's check out the next slide. Hopefully we've kind of oriented now. Well, how can you safely buy leads, Puja?
You start with knowing who your partners are. That's the most obvious, right? And then you want to build those relationships, and I'll touch on those details on our next slide. You want to take your interview process and your vendor intake forms really seriously, assuming you have these vendor intake forms. And then the obvious is contract terms, right? Use outside counsel, develop a good template for a contract for your partners. This is a relationship, and though these folks are your friends, you also want to make sure you're protecting yourself and your company. That's what you're there for. And then you want to continue to monitor your partners, making sure that they're honoring the terms of your contract and they're continuously honoring your standards. And then lastly is your strict internal standards, right? How are you holding your business accountable? How are you making sure you're working with other vendors to make sure your lead partners are also doing the same accountability that you are doing internally as well?
Yeah, so those of you that are in the business of buying leads and those of you that are in the business of selling leads, I mean, this is a really important slide. I took a look at this when Puja put it together, and I was thinking, man, this is worth the price of admission, to the masterclass. And this is why we have these things. Really kind of critical little checklist right here. And I know we're going to break these things down each slide, but I mean, hit the print screen, right? Hold on to this. This is valuable stuff. Every single one of these little bullet points, I think it has real value. And given where we are with this litigation cash cow and this brand protection, you can't really let any of these issues slip. I feel like I'm the color commentator. This is kind of cool. Who's just giving the play-by-play, and I'm just kind of color commentating. But let me just do a quick shout out also, Neal. The summit, oh my goodness, the summits are back. The Florida summit, 2 days of TCPA goodness. You guys have to be there in Florida. It's so good. It's so good. We'll talk about that some more in a bit, but I just had to mention that. All right, next slide.
So how do you deal with the business, right? I'm often referred to as the sales prevention department, and that's difficult to maneuver, but what you really want to do is you want to communicate with your business, right? You want to let them know the importance of protecting your brand. You want to educate them. I have no problem directing my folks to go read TCPAWorld or listen to a podcast to the extent that it's impacting their day-to-day business. I'm constantly keeping them apprised of what our competitors are doing so we don't make the same mistakes, and we learn from their mistakes before we learn from our own mistakes. And just letting them know, we understand we're operating a business. We all want LoanDepot and other companies to do well, but we also need to protect them. And so I find that just really communication is key, and being clear with them about what your requirements are, and not having any fuzzy areas of what they're allowed and not allowed to do is extremely important.
Puja, can I ask a question? From your channel, a lot of clients, when they buy leads, they'll create test cells, and usually the KPIs are about some sort of ROI. Did it convert? Do you also advise that your marketing team look at, for instance, complaint or non-connect issues or the metrics of communication to look as an early warning device, other than just seeing how much sales that we get out of it?
Actually, well, let me jump in though, because we don't want to get too specific into what LoanDepot is and isn't doing necessarily. We're going to be we'll be careful here. But let me just respond by that, and I'll if it's okay with you, Puja, I'll take this one. To say that anytime you're onboarding a vendor, I know Puja is going to talk about this here in a second. Anytime you're onboarding a vendor, it is important to, whether you're doing it, to test the quality of their goods from an ROI standpoint or from a do not call standpoint, or whether you are doing some different form of diligence to assure that this vendor is doing what they say they're going to do. It is critical that as part of the vendor onboarding process that you vet them. And that's really kind of what you're driving at, right? There are different ways to vet them. And I don't want anyone to take away that there's only one specific way to vet, or if you're not vetting in every particular way, that you're somehow falling below any sort of standard of care in the industry. But you do need to vet them. You do need to make sure that these folks, to Puja's original point, that you know who they are and that you can trust them. And that requires an understanding of precisely where the leads are coming from and how they're being engineered, and ultimately what you're buying, and then making sure that you as a buyer are comfortable with that. And there's a lot of ways to skin that cat. Okay.
Yeah, and go ahead, Daniel.
And don't be afraid to ask vendors questions. One thing we see when we go out and speak to lead buyers is they sometimes feel awkward pressing their vendors, asking them too many questions. Well, if your vendors are pushing back and unwilling to answer questions, you do not want to work with them. If they won't open up the playbook to you, it means there's something in there they don't want you to see. And a lot of times those are compliance risks.
Yeah, you're going to, just buying leads, you're going to have inherent business leads, right? Such as fake leads, for instance. But, don't be afraid to limit these risks by, calling certain partners and using a flight to quality approach, until you can weed out the folks that you're supposed to work with and shouldn't work with. And you're really weeding out those bad fake players.
And by the way, on the sales, before we leave this side, the sales prevention department, one of the beauties of lead generation now is it allows for very specific micro targeting. You can target people within a certain zip code who want a certain type of auto policy within certain parameters because they click on an advertisement advertising it. Why would you want to call them and offer them health insurance or a mortgage? You're spending money for micro targeted ads. Call on within the scope of those ads, not something out of left field.
Head to the next slide. So, as Daniel was just saying, you must get to know and manage your generators, responsibly, and exercise due diligence when, you're onboarding them. You don't want to work with lead partners who aren't willing to communicate and only provide you with vague information. Get the details you need in advance to make an assessment, right? Don't partner with folks who are known to be non-compliant, and, you have to continuously vet these folks, touch base with them every 6 months or a year from now. You don't want to work with folks, obviously, who are using unlawful tactics to generate leads or illegally calling customers registered on the DNC behind your back, for instance. You also want to make reasonable efforts to stay involved in what's going on in the industry, right? The obvious is TCPAWorld.com, but also our friends at DNC and Leads Counsel put together regular fantastic conferences throughout the year where, you get free Eric Troutman, but these conferences are only a great resource to hear him speak, but it's a great platform to help create better relationships between buyers and sellers. And, that's often lacking. And, lastly, join Leads Counsel. It's a critical organization in this space and will introduce you to major players in the industry. I'm extremely proud to say that I sit on the board of an organization like Leads Counsel, where their mission statement is to educate and advocate on behalf of both buyers and sellers in the lead generation industry.
Yeah, and so again, look at these bullet points. Who just put this stuff together? There's a lot. Honestly, there's a lot of wisdom here. So if you are a buyer, you should be out there at these conferences. You should be getting information, not just about the law, but you should know who the players are. Who are these? Because your business people know who the players are, right? If you're in legal and compliance, they're going to come to you and they're going to say, you know, use this guy, use that guy. We want to use so-and-so. Do you know who these people are? Right? I mean, ultimately, part of your mission in protecting your organization against the potential for buying bad leads is to make sure that you actually can eyeball these people, right? And the second one is really important. If your lead partners aren't willing to talk to you, to your legal department, to you know, put somebody on the phone to have a coherent conversation, that's a pretty big red flag, right? And simultaneously, to all the lead sellers I'm talking to right now, you know how this works, right? You know, Puja is going to get on the phone and she's going to want to talk to you. She's want to know exactly what you're doing to make sure that all the requirements that you know, LoanDepot as a good institution is going to require of its lead partners, and that's not going to be unique to just Puja. And as this industry continues to mature and develop, and awareness both of compliance concerns and of course of the need to honor contact preference continues to evolve, you know, these relationships are just going to get more and more important. And Leads Counsel, look, I'm not on the board for Leads Counsel, but you know, they are moving toward self-regulated status, right? They're moving toward trying to put together standards for the entire industry, and directionally, it will not be long before all the lead buyers will not buy unless you as a lead seller are part of this organization and adhering to certain standards. That's not here today, but directionally, that's where we're all headed. I mean, that's just reality, right? This is going to become a self-regulated industry, and the big buyers are just not going to buy anymore unless best practices are being adhered to. So, you know, get smart and start kind of joining these organizations and understanding what the future looks like. It's kind of my 2 cents.
Yeah, and you know, I'll be honest with you, when I was working alongside Eric defending these TCPA litigation matters, I didn't have much of an insight into this lead generation ecosystem, right? I didn't really understand how it operated. I knew how to defend these TCPA matters. I didn't really get engaged and involved and understand who these players were really until our second or third DNC conference probably. And then, you know, more so now with my involvement in Leads Counsel and, you know, being in-house, I see the importance of being involved, having lunch with these folks, getting on the phone and just really knowing what they're up to. And you get to learn what their standards are and what they're comfortable with and what they're not comfortable with to make sure that's aligning with your company.
I think in any industry, right, there's going to be those that really take something seriously, and there's going to be those that are paying lip service to it. When you're engaging with your vendors repeatedly on an ongoing basis, delivering message over and over and over again as part of a relationship, you are conveying to those vendors that you take this seriously. It's not lip service. It's not just something you're doing at the start to vet, to check a box, right? And that, you know, the overall saturation of these contacts really kind of leaves the impression that your institution as the buyer is not to be messed with. And if they're going to pepper the steak, or they're going to do a little something, you know, kind of shady, well, don't do it here. Do it over here if you're going to do it. And of course, you shouldn't be doing that at all.
All right, let's go to my favorite slide. So, you know, after you have met these folks, you're understanding who your business is already working with, who they want to work with. You know, how do you really understand whether they're going to be compatible with your business and your business's standards? Interview them, right? Develop a list of questions to vet your potential partners to see if they're willing and capable to meet your standards, right? This is a time to look at different things, right? Possible data points to leverage in assessing vendor relationships include, you know, past TCPA claims, DNC rates, right? Percentage of your market share, conversion rates, et cetera, all that. But initially you want to start with what system are they using, for instance, right? Are they doing outbound dialing? Are they giving you warm transfers, right? What's their consent language? How often are they changing their consent language? Do they think they're operating under an ATDS? And if not, why not, right? You want to ask these questions. You want to have an open conversation with them. You're not often going to get detailed responses or really, you know, the responses you may want. So that's your time to either say yay or nay, right? Give the green light. You know, this is a relationship. You want it to work. So do the legwork before entering into the relationship. And, you know, the only way you're going to feel comfortable is if you get your answers outright in the beginning. And you don't want to, one thing you want to be careful about is, you know, as either Daniel or Eric were saying, that the business has probably already been working with a lot of these folks. So if you're coming in on the back end at a later time, like I did, for instance, you really want to ask these questions so you can provide the business with the proper guidance as to why they should or should not continue to work with these folks. And, you know, it's better to, you know, do it on the front end so you're not upsetting your business later down the road, to let them know like, hey, you know, I looked at this and I don't think it's compliant. We should cease working with them. And they're already 2 years in with working with these folks. You know, to develop your own questionnaire, right? That's what I did. It works for me. It at least gives me the groundwork to start to get to know my folks.
And Puja, let me just point out, I mean, this is a little snippet of just kind of the top. I mean, this is a long thing. I mean, it's not like 4 questions, right? I mean, I presume it's like 25 or 30. Is that right?
Something like that.
Well,
Yeah.
I mean, go ahead, Daniel.
Well, and just remember, if the business knows of something negative, but the legal department doesn't, and a regulator comes in, they're not going to say, oh, well, the legal department didn't know. They're going to look at what the company knows. Same thing with the court. If you're sued, they're going to look at what the company knows. So you can't really, it's difficult to stand up. I mean, you can do it in some context, but it's difficult to stand up and say, oh, what? No, the compliance guy over there, it didn't know about it. Only this marketing guy, therefore we shouldn't be held accountable. That's not a position you want to be in. You want your compliance department or your legal department to know what your sales guys know, because you are on the hook for what they know. Also, when you go in, pretend that you're a regulator. Think about what a regulator would want to know, because those painful questions that a regulator would ask, those are the ones you want answered ahead of time.
So, and let me just point out one more thing, right? LoanDepot is very fortunate because they've got probably the best associate I ever had, a real TCPA expert and just kind of a very, very thoughtful lawyer in Puja, who can design this TCPA D&C questionnaire. And as you heard her say, she created it. Not everybody is going to be in that position. I don't want anyone listening to feel kind of overwhelmed and think, oh my God, I have to put together a 25-point questionnaire in order to take on a vendor. You know, feel free to work with outside counsel for that sort of thing, right? That's where you want somebody looking over your shoulder, kind of spotting issues for you so that you can understand exactly what's important in this context. And then, you know, to the extent you want to waive something off and take a certain risk because your institution has that tolerance, that's fine. But at least you'll know kind of what the universe looks like, and you can deploy it strategically as you see fit to try to get this information at the front end. And of course, it's dynamite in litigation when you're trying to demonstrate good faith and when you're trying to demonstrate that, you know, you were not aware, if ultimately it turns out that this vendor is a bad actor, that you weren't aware of it. I mean, here's your evidence that you were vetting and trying to get information that assured that they were good actors and not bad actors.
Hey, Eric, can you repeat that point again, that, you know, this vendor management as part of your compliance is a key element in some sort of defensive strategy if the wheels come off the bus?
Well, I mean,
right?
it's critical, right? I mean, ultimately we're doing this, we meaning, you know, you lead buyers, right? You're vetting your vendors because you sincerely don't want to work with people who are violating the law. But understand that you're also doing it because you need to prove one day that you took reasonable steps when you were onboarding this company, that you can't be sued as some, you know, cavalier company that turned a blind eye to the source of leads, or that turned a blind eye to the fact that the people you were working with were scumbags, right? One day it will happen. If you're working with a scumbag, it will happen. You will get sued and you will say, well, look, my contract with them says they could only give me valid leads. And some courts will say, that's enough for me. Other courts will shrug and say, I don't care what the contract says. What did you do to make sure that you were not dealing with a scumbag? And if you don't have something to show, something to point to, then that judge might decide that you knew or should have known, or behaved recklessly, or otherwise fell below a standard of care that that judge is going to apply in this context, and find that you can be held liable for these phone calls. So it's just good business practice to assure, again, make sure your brand is safe. But from a litigation standpoint, it's dynamite evidence in the context of trying to tell the court that you acted reasonably and responsibly and had no idea, in essence, that the scumbag was a scumbag, if they're a scumbag.
In the Federal Trade Commission and Consumer Financial Protection Bureau expect you to exercise that oversight and due diligence. Putting it in the contract and then saying, oh, didn't know, didn't check. They're going to say, well, what did you do to check? What did you do to monitor? And if the answer is nothing, you're not going to be in a particularly good spot.
As you can tell, Daniel's constantly defending these CIDs and these government outreach and audits these days. And I mean, this stuff is important, right? I mean, the FTC, you folks may know this, right? Following the big AMG Capital decision, the FTC had its, what I'll call it, streamlined monetary damage restitution remedy taken away from it by the Supreme Court, which means it has to fall back on its more robust CID process and the administrative law process. What a surprise that we saw a huge number of CIDs come out in the first quarter of 2021. It's almost as if the FTC knew what the Supreme Court was going to do. And as a result, it started gearing up for the more formal processes with these CIDs. So to your point, Daniel, vendor oversight from a regulator perspective is more important today than it's ever been. And that's just one more overlay on top of course, the litigation risk that I was talking about earlier. Puja, anything else on that? Should we go to the next slide?
Well said. And let's go to the next slide. So, as important as the vendor questionnaires or interviewing your vendors is contract terms, right? Use outside counsel for this if you can't do it in-house or if you don't have an in-house attorney who's capable of putting one together. At the end of the day, I made a lot of friends in this industry and, our lead partners are our friends, but you have to protect your business at the end of the day, right? You're not here to make friends, you're here to do your job. And you start with establishing strict contractual requirements, which lay out your standards for compliance, right? One thing to keep in mind is don't forget to amend and update your agreements and standards where they're necessary. As we all know, and as Eric constantly stresses, there's constant changes in TCPA world and new legal interpretations going around all the time. So, get those things signed, keep them updated, make sure that they're in line. Because if you forget, if you signed a contract 5 years ago, as you know, the laws changed drastically since, and your standards may or may have not changed in light of the new legal requirements. I highly recommend here to consult with your outside counsel and making a template that fits your needs. And make it clear to your partners that you're going to use this and you're not going to work with them unless these are signed, right? So there's no room for them interpreting your standards or he said, she said type of situation. And seek indemnity, right? You want to hold these folks accountable, right? If you need to sue them because they did a wrongdoing and they intentionally or unintentionally went against your contract terms, you want to hold them liable. That's the only way we're going to make this industry better, is by holding the bad actors liable. And terminate them, to the extent that they're violating any contract terms, stop using them, learn from your mistakes.
Yeah, so I want to highlight a couple things on the slide, Puja. Were you done? Hopefully I didn't cut you off.
Yeah, go for it.
So first, drafting your contract terms is really important, and we've seen that increasingly. There's been two really big cases, the McCurley versus Caribbean Cruise being like the most remarkable case of a defendant really in a lot of trouble in the case procedurally, looking really potentially at a huge judgment that was able to fall back on its contract terms, essentially to win the case, which is great. So you want to be really thoughtful about how your contracts are being put together, but there's kind of a tug and pull because, as many of you folks are, the more sophisticated lawyers and compliance folks on the phone know, if you exercise too much control over these third parties by being too ticky-tack, for instance, and what they can and can't do, and going about, for instance, generating leads or making outbound calls, whatever the case might be, depending on your vendor, then you're going to be found to be responsible for their behavior as a principal controlling an agent. So there's a real fine line, frankly, in terms of how you're drafting these terms and conditions to assure that, one, they're doing everything that they're supposed to do, but two, that you're not inadvertently taking responsibility for things if they do what they're not supposed to do. So look, if you've got great sophisticated in-house counsel, wonderful, they know what to do, they're going to draft these agreements appropriately. But if not, again, this is a really good place to turn to outside counsel with these thoughts in mind. Like, many times outside counsel is not familiar with the TCPA or these sorts of vendor relationships won't get it. Raise this to them, right? To your lawyer, say, I want to make sure, on the one hand, that this vendor is complying with the TCPA and agreeing that they will comply with the TCPA, but on the other hand, that I don't become a principal. This needs to remain an independent contractor relationship where they're a third party, and we're not going to be liable if they violate the law, right? And your lawyer, whoever it is, should be able to navigate that. It's tricky, but they should be able to. One last thing is this last piece down here, Puja, that you identified, which is you as an institution always need to make a decision as to whether or not you're going to accept leads from third parties or affiliates, right? You enter into a contract with, Bob's Lead Shack, right? What are you buying? Does Bob's Lead Shack own 100 digital properties and they're giving you nothing but leads from those properties and nothing else? Or do they have a network of folks, some of whom are publishers, resellers, generators, and some who have properties or whatever? What are you buying? What are you agreeing to? You've got to make sure you, and I don't mean you as the business, I mean you as the compliance or legal officer responsible for making sure that vendor intake is being done in a responsible way. You need to make sure you understand fully, where are these leads coming from, right? And there is an argument to be made that buying leads from networks that have affiliates or that buy downstream and that things get aggregated or pick up from different properties, that's fine. And I'm not here to tell you categorically that you shouldn't do that or that it's too dangerous. I'm not here to say that. But I am here to say that you need to understand what risk you're taking on. And if you choose to take on that risk in the name of greater volume, that's cool, right? I'm not telling you not to, but you have to understand that you're doing that. And you should make that choice intelligently. And you can split the baby, right? You don't have to go, everything or just, nothing but the actual publisher of the specific property and nothing more. And the disclosure has to be specifically chosen by me, which, by the way, is one way to be conservative and safe, right? You pick only vendors that only have properties that have disclosures that you vet, you identify, you agree with, mention your product as your name as the seller, and nothing else ever will you buy. That's one option, and it's not a bad option, frankly. But just whatever you choose to do, my point is, do it intelligently and make sure you understand what risk you're taking on.
Hey, Eric, one other thing, not only where those leads are coming from, but also when, correct? Time. Are those 30-day hotlines really 30-day hotlines? Yeah, right? Because there's a time limit on an inquiry, correct?
There is a time limit on an inquiry and beyond, of course, as we talk about all the time, beyond the strict time limits of an inquiry, because if you've got a express written consent, and there's a tug and a pull everywhere, right? Pre-Facebook, all of these would ostensibly be express written consent. So that would trump the DNC rules, although there's still a scope of consent. So, if you're in the market for a product today, that doesn't mean you're in the market for a product 6 months from now. And at some point, the express consent never expires technically, but it would theoretically at some point, the scope of that consent would cease to exist because the consumer is no longer interested in that product. Setting that aside, though, after Facebook, as we know, people are starting to deploy truncated express consent documents that are not going to pass the EWC rules. So if you're using technology that's going to trigger the statute, that's a big issue. But even if you're not, of course, now you're falling back on just 90 days on an inquiry because that's not going to qualify as express written consent for DNC purposes. So, I mean, you run into that scenario all the time and you're thinking you've got limitless express consent because, hey, it was in writing, but it doesn't meet now all the FCC's requirements. And guess what? It's not worth the paper it's printed on as express written consent. It's just not. So now you're back to that 90-day window, right? Keep all of that in mind. And as Puja was saying earlier, you also have, while we're talking about scope of consent, you also have the multi-vertical problem, right? If you enter into an agreement to start buying leads and they're going to sign off, they meaning the lead provider is going to sign off that, yeah, sure, these all have consent. If you're not vetting where the leads are coming from, what the sources ultimately are, if they're part of an affiliate network in particular, you might see multi-vertical leads that, I mean, the consumer's expectation is really, maybe it's defeated because they think they're agreeing to leads for circular saws, and now they're getting calls on house paint, and technically that's in the fine language, or mortgage insurance or vehicles or God knows what else. Is that going to be enforceable? It's a tough sell. So there's a lot of issues here. And again, all of this is just driven to make sure that you, as the legal professional, as a compliance professional, as the person responsible for vetting vendors, as you're buying leads, allowing your organization to buy leads, are thinking through exactly what these leads look like, where they're coming from, and what the scope of the disclosure is so that you can operationalize and make use of it, whatever it is you're buying.
Sure. We're getting a few questions about what do we mean by make sure the leads are compliant. What sources of law are out there with the Telephone Consumer Protection Act and FCC, in particular, FCC rules implementing it outline generally what you need to have for a lead to be compliant. Disclosure it has to have proper disclosure requirements. You have to capture it so you can actually prove that you received it. The call has to be within the scope of the disclosure. We're going to get to all that later in the webinar, but I wanted to highlight that really quick before we moved on.
Yeah, let's go to the next slide so Eric can get to, what should your standards be and why. So, lastly, after you've done all the previous steps that we've mentioned, continue to monitor your folks, right? I think I've already said this, but, don't be afraid to take the flight to quality approach, and don't be afraid to cut bad partners if in the event that you find that later down the road, they change their standards or they're no longer compliant. Continuously monitor them. It doesn't hurt to do a self audit or a routine investigation, see who's getting in trouble and who's not. There's many tools out there like Journaya and Active Prospect to make sure that people aren't cheating and providing you with the consent that you've required to the extent you have. And there's also tools out there to help you enhance stuff like phone number verification, right? There's plenty of tools out there. DNC also has a great product called Litigator Scrub, right? There's things you can do to continuously monitor where your leads are coming from, what they look like, and really the quality of the leads. Next slide. And then have your own internal standards, right? Establish those policies and procedures, but also implement them, right? It's very easy to get the policies and procedures drafted and written and put into your system, but are you ensuring that your folks in your business, your compliance folks, are complying with these policies? You've heard Daniel and Eric talk, right? You can be held liable by these regulators for not doing your due diligence and making sure that you are also complying with your own policies and as are your partners. Once your PMPs are in place, provide training, talk to your business, tell them what they need to do to protect themselves, tell them what they should be looking for when they're talking to lead partners and when they're talking to other vendors, so they can also establish a good consumer brand and protect themselves from liability. Stress the importance of third-party verifications, stuff like Litigator Scrub, and upholding the terms of the contracts you put in place. So again, this is where communication with your business is extremely important. And lastly, use outside counsel, right? If you're uncertain about a new campaign or a new law that's out there, don't be afraid to use outside counsel to the extent that you don't understand what what the new changes are.
Well, let me emphasize this, because even if you do understand, let's back up. One of the things that any legal professional or compliance professional listening to me should keep in mind is that the business doesn't always get it, right? They're under pressure to sell. And they don't think they have any skin in the compliance game beyond, whatever institutional qualms they might run into, getting their wrist slapped by legal. They are personally liable, right? And you should emphasize to them, hey, dear business guy or dear business gal, you want to contact consumers using different outreach strategies. Cool. Understand that if you don't run it by me and you end up doing something, deploying something, approving something that's illegal, you are personally liable for that. Not just the company, you, dude, like your personal bank account, your car could be seized after a judgment because of what you did. So never initiate a new outreach campaign without running it by legal, right? That's the messaging that, if I was in house, that's what I'd be telling my business people. Like, this is not, victimless crimes. Like, you could really be in trouble if this goes the wrong way. Second, if you are in-house compliance, right? I think the rules are a little bit different for in-house legal, but in-house compliance, and if you're not in an attorney relationship, or if you're an officer who is stuck with compliance, understand, like, folks get personally sued just for wearing the compliance hat. So what you want to do is, it's not just if you're unsure, even if you think you've got a pretty good sense that this is legal, run it by outside counsel. That way, when the discovery comes, who approved this? Who, what personal person am I going to go sue? Well, you can sue Eric Troutman at Squire Patton Boggs. Good luck, right? That's the concept, is now the directive isn't coming from anywhere, but outside counsel is blessing this as an approved form of communication, of approved outreach method. So no individual can be viewed as the one that is personally kind of participating in the creation of this. Now, that's not going to be completely bulletproof, but it gets you a lot closer to being safe from this personal liability trap that's out there. Hopefully that makes sense to everybody.
Remember, policies and procedures are two different documents, serve different purposes. With respect to procedures in particular, do not rely on an off-the-shelf procedure. Make sure that it's customized to your actual business, because you will be held to the standards set forth in that procedural document. And if your actual practices do not match what's in your procedures, that can cause you a lot of issues in litigation. It can lead to a class becoming certifiable, whereas otherwise it might be difficult. It can cause you a whole lot of issues with regulators because they will test you against your procedures.
Hey guys, essentially, isn't this what we're really saying is watch out for the disingenuous nod towards compliance. The working group, the litigators, the regulators, that's what they're looking for. Did you just rely on your reps and warrants and you don't do anything else? Or you've got this great policy statement and nobody in the company knows it. Disingenuous is going to get you hammered.
Yeah, and at the end of the day, if you're not holding, your internal folks liable or, up to these high standards, how can you expect your sellers to meet those same standards? So,
Good point.
Yep.
And if you pay Eric and I a bunch of money to create these great policies and procedures for you, and they just go straight to your shelf and you never look at them again, you have just wasted your money.
And then you'll be seeing them again in litigation.
All right, next slide. That was a really good one. Okay. So Daniel, this goes to the questions that were being asked earlier about like, what is consent? If this is your first masterclass, then you're going to be thinking, oh, what a great slide. If this is your third masterclass, you're going to be thinking, I already saw this slide twice, but it's worth touching again. So Daniel, why don't you go ahead and break it down?
Sure. So really the key is, obviously you want to make sure you have all these 9 points, but the key is, can the person actually understand that they're consenting? If you grab somebody off the street, if you grab a retired couple at Publix or Walmart and show them the consent, would they know what they're consenting if they're just going through the website? What's really tripping up a lot of companies is they've gotten creative with where they put the disclosure, the consent disclosure language. It's masked in a bright, colorful website with 10,000 things happening around it. It's above the consent's buried below the button rather than above it. And you'll have your web developers and designers say, well, we're going to get a lot more consent if we have this nice, pretty website with a lot of things going around. Well, one of the reasons you're going to get a lot more consent is because people won't actually read it. You need to make sure people actually read it and it's understandable.
Yeah, we're going to talk about format secondarily, but first, this slide. So anyone that's thinking about capturing consent, express consent, I've said this a few times, but if you're thinking about capturing express written consent, you have to think about it in 2 buckets. Okay, 2 buckets. Bucket number 2, we're going to get to in a second, what Daniel was just teeing up about format, how it looks on the screen, the consumer experience. Bucket number 1, though, content. And content is not, hey, what's the guy at Walmart think? It's not, hey, what's the reason? No. Content is specific. It is dictated by the regulator in the regulations. It's not common sense. It's not user-friendly. It's a mess, frankly, but it is black and white law. You have to have certain pieces in your disclosure and you can't cheat. And it doesn't matter if you can argue, well, the consumer knew or should have known, or come on, it was obvious. No. None of that is going to fly. Either you meet the requirements of the regulation in the content or you do not. So this slide gives you the content requirements. You absolutely have to mention marketing or promotions. You just have to, right? I know you don't want to, but you have to. That's what the regulator says. You have to mention the use of automated dialing technology. You have to. If you're going to use pre-recorded voices or artificial voices, including IVR or ringless voicemail, et cetera, you have to say that, right? These are pieces that have to be in there. You also have to say that the acceptance of the disclosure is not required in exchange for any good or service. It's just mandated. I wish you didn't have to say that too, but you do have to say that. And oh, by the way, it has to be true, right? There actually has to be a way for that consumer to get your good and service or service without providing that telemarketing consent. So all of this has to be there, right? So bucket one, right, when you're thinking about how you gather consent, or more importantly for this discussion, what you're thinking about requiring your vendors, your lead sellers that you're buying from to provide, it has to be these 9 things. It has to be all of them. And when we start thinking about specifically the seller and the scope, that's where things get very interesting, because of course, many times it's difficult for sellers to identify, and here I mean lead sellers, to identify all their partners who are also selling products to the consumer. But your name needs to show up either in a hyperlink or otherwise. Otherwise, you're in harm's way. You're really at risk. And then tying this all the way back to Facebook. Remember, we talked about Facebook before. Facebook, right, narrows the reach of the TCPA. So there's going to be less need, frankly, for express written consent in certain contexts. But Facebook does not change any of these 9 requirements. Facebook does not change the regulations around what express written consent requires. So if you need express written consent, including to get around D&C restrictions, the same rules apply. Beware, my friend, of the wolf in sheep's clothing. Beware the express written consent that's not real express written consent. Beware the post-Facebook express written consent, where people are cutting corners and not putting all 9 requirements in because they figure, post-Facebook, does it really matter? Well, either it does matter or it doesn't. And if it turns out that it does, because, for instance, you're using technology governed by the TCPA, or a D&C rule applies, if it does, it's really going to matter. And if you are blindfoldedly relying on express written consent that is not express written consent, man, you are in trouble. Like, you are in big, big trouble. So my advice to you is either don't get consent at all and just know that you don't have consent, so that you don't have to have a concern about, is your consent valid, or get all the consent the right way the first time so that you're covered in any instance.
I'd like to add, all these components, take it back to the brand protection, right? Giving the consumer what they want, right? If I'm looking to buy a vehicle, do not call me, do not contact me about circular saws, right? All these components that Eric has laid out for you, they help with your brand protection, because you're calling the consumer about products they are actually searching and looking for.
Okay. And I should point out at this moment, like, I don't want it to seem like we're in any way disparaging the lead industry. It's a critical industry, and it really does help connect interested buyers of products and services with people that provide those products and services. And that is in and of itself a valuable service. It's valuable, obviously, to the ultimate seller. It's valuable to the consumer. It's all good, right? The whole lead industry is a very good, very consumer-friendly thing when it's done right. It's just when it's done wrong that it becomes very problematic. All right, let's go to the next slide. Okay, here's what Daniel was just talking about, is if there was a critical trend in 2020, the big trend, and again, if you've attended the previous 2 master classes, you've heard us talk about this, but you're going to hear it a third time. It's good, right? This kind of repetition is very valuable. There was a huge trend in 2020 of courts refusing to enforce contract disclosures, consent disclosures, arbitration disclosures online. And in the first master class, we gave you a bunch of really cool visuals. You can go back and pull up those slides if you haven't seen them yet, showing you exactly what the courts looked at and why the courts found that it was not going to cut it. But the bottom line is, and this is going back to what Daniel was saying, right? Transparency, consumer experience. The courts are essentially putting themselves in the consumer's seat, going through the website themselves. Can you imagine this? Some federal clerk, some federal judge somewhere going through your website to see if the consent makes sense. This is what they do, right? I mean, literally, the rulings show us that the courts are really paying that much attention. And they go through the flow and they put themselves in the mind of the consumer and think, is the consumer being confused, tricked, duped, misled in any way, shape, or form? Is that disclosure far at the bottom? Is there some element on the web page that is distracting the consumer and inviting the consumer to look away from the disclosure? Is there anything really that might be viewed as the disclosure, thinking they're getting one thing, but really signing up for something else? If any of those elements are present, either as part of the specific website where consent is given, or as part of the overall flow of the website, right? The flow of the consumer experience in your online ecosystem, whatever it is, if that is in any way, shape, or form misleading, you got to be careful, right? And if you're buying leads, again, if you have your own website, right, you are in complete control as to what that consumer experience looks like. But if you're buying leads, you need to get your nose in there and find out, what is the consumer experience look like on your website lead seller, or on your affiliates websites lead sellers, right? I mean, you really have to understand it, not just the content of the disclosure, right? To a certain degree, we've grown past Journaya and Active Prospect, really critical tools, obviously. But to a certain degree, we have to go even beyond that now, right? It's not just the content of the disclosure that matters. It really is the entire visual rendering that those solutions will give you, the layout of the website, and sometimes even the layout of the page before the page where the consent is actually given, right? You can imagine many funnels, many consumer experiences where that consumer is being misled on page 1. Page 2 might be nice and pristine and clean, but based on page 1, they thought they were doing something different than they're ultimately doing. None of that stuff flies. These courts are being real ticky-tack, frankly. So to Daniel's earlier point, like, you got to make sure that you really know what you're doing here.
Hey, Eric, can you restate? We had a great question. I know, Daniel, you're typing an answer to it, but one of the attendees sort of asked, if the wrong person gave you consent, so you really had the best practices, somebody else gives you consent, what happens there?
Yeah, it wasn't me continues to be a problem. Journaya Active Prospect gets you pretty close to it. IP tracking is very helpful. But we are seeing a lot of this. And the problem ultimately is that all web page submissions are technically anonymous, meaning, yes, I'm putting some validating information in there, but at the end of the day, there is no one having to put their fingerprint onto a computer console somewhere in order to access your website. And until that day happens, you're not going to have positive credentials for a new customer. Now, you will for an existing customer, right? They'll have a sign in, so that's helpful. But for a new person coming on to your website, you're not going to have that validation. So what do you do? Well, there's a lot of things you can do, right? You can, for instance, subscribe to Lexis or eBureau and have the phone number, address, and other pieces of information that consumer provides verified against public records in more or less real time, get a confidence score back. Same thing with subscriber information using Neustar or other vendors. That stuff is all out there. I will tell you, though, there is no complete fix. And Daniel and myself and others actually are in front of the FCC right now, urging the commission. And if anyone from the commission is listening, I mean, I don't think you are, but I mean, they know about this, right? This is an issue. And the issue is, it's just backbone critical for e-commerce in this nation. Can American businesses safely rely on web form submissions and reasonably rely on those submissions to make phone calls and reach out to consumers? Yes or no, right? Under the current state of the law, it's a question of fact that goes to the jury. And if the jury believes that the plaintiff didn't really put their name in there, then you have no defense.
And we still have, and actually one of my team members, Ryan Thurman, pointed out, Ryan's subject matter expert here, a tremendous amount of clients are still in that area where they're having to run in real time litigator scrub, because a lot of the bad guys specifically use that tactic, try to get to court and say, it's not me, filter them out. We spend a lot of time trying to find the bad actors, and they're not always on the DNC list, right? The two completely separate different data scrubs. But it's unfortunate they have to do it, but you have to do it.
Yeah, no, they intentionally aren't on the DNC because they want to essentially get these phone calls and set up these lawsuits, which I thought I shut down when I won that big Stoops case a while back, but I guess this lives on. But the bottom line is, we're hoping for positive help from the FCC on this really critical issue. It's very common sense. To me, it's just very common sense. Obviously, if you get information on a web form, you as a business have no idea that it's not true or truthful, or that the submitter is not who they purport to be, and you rely on that, you should have a defense. I mean, to me, that's very, very obvious. But in the meantime, you have to monitor for bot traffic, have the litigator scrub, look out for things like Tor exit routers, right? These plaintiffs are trying to set up cases. They're trying to get phone calls, net phone calls, and they will deny that they provided you the information. And I've seen them do it under oath, whether they're lying or they have a friend doing it for them, and the question's not quite being asked right at deposition. Who knows, right? I'm not here to point fingers or tell you who's doing what specifically, but I'll tell you, we see a heck of a lot of lawsuits from seemingly valid disclosures that just happen to have been submitted by somebody with a last name that shows up in the docket as a plaintiff all the time. I don't know how it happens.
I know we're at the top of the hour. Can we keep going for a little bit? How's everybody doing on time here? We still have the audience here. Can we hang in for a little bit longer?
And we can hang in. See, this is what makes the summit so valuable, right? Is you never run out of time. You've got 2 full days, you've got the happy hour, you've got the lunch, you can hang out, you can talk, you can connect, and you can just really immerse yourself. These things, we always run out of time. It's really frustrating. But yeah, let's stick around for a few more minutes. You know, I see the participants are starting to drop though. See, if we get under a certain number, I'm just gonna be like, sorry guys, let's just end it. But let's keep going. What else do we got? So this is Facebook. Obviously, we've kicked around Facebook earlier. Just remember that there is still risk out there, and you have to fully understand what your vendor is using. If you're using software, you have to understand what your software is capable of doing. And again, this bleeds in powerfully to your lead buying experience, right? If you are deciding that you are going to buy non-consented leads, or if you're deciding that you're going to be buying leads through an affiliate network, think about what that means in terms of what technology you intend to deploy to engage in outreach with those individuals. Think about what Facebook says and what it doesn't say, and make sure that you're, again, making intelligent risk assessments. Reach out to your vendors and have them tell you, what does your system do? Have them promise you that it doesn't do the things that Facebook says it's not allowed to do. Remember, capacity is still an issue. It's still an issue, folks. And the functionalities that are required, which include the use of a random or sequential number generator to either store or create phone numbers, it's still a little vague what that means, particularly after footnote 7 there on the screen. So there's a lot of, I said earlier, meat left on the bone. There's a lot of meat left on the bone in terms of what is an auto dialer after Facebook. And if you're going to be deploying a strategy where you are contacting consumers without consent, you better know. I mean, not, what was that old line from Ocean's 11? I mean, you better goddamn know before you mess around, that system is not an ATDS.
And even after Facebook, pre-recorded messages still covered. DNC violations, you could call from a rotary phone. It's still covered.
And Puja, I know last time we talked, LoanDepot is going to continue to maintain the course post-Facebook with its consumer-friendly outreach approach as kind of a leader in the industry, I presume. Still more or less where you guys are at?
Absolutely. And, this goes back to what I was saying, continue monitoring your folks to make sure they're keeping up with what your decision, what your standards are post Facebook and other significant decisions.
Yeah, and look, my advice hasn't changed, right? The day after Facebook, I gave you my red, yellow, green. I told you what is good, what is not good, what is, less than not good, okay? That hasn't changed at all. I haven't budged a minute, but I'm telling you, although I'm continuing to say the exact same words that I've been saying since literally hours after the decision came down, the phone calls I'm getting are just totally different. They're just totally different, right? People are moving past it now. They're moving into the new realm where they want to be more aggressive. And that's okay. That's the decision that you want to make. Just make that risk assessment intelligently, keep your brand protection and the potential for personal liability in mind. And just remember, there's a lot of pieces to this, right? The ATDS piece is just one piece of a much bigger puzzle. All right, do we have any more slides, Neal? I think we're wrapping up here.
We have, that was the big money slide.
There you go. There's my red, yellow, green.
Yeah.
So, I mean, look, let's open it up to questions. If there are any, I'm happy to stick around for a few more minutes to answer questions. I know questions, frankly, are what's the most valuable pieces here. And these summits are so good because questions can be asked. And you get, not legal advice, but you get me spending some time giving you the answers to the questions that you might have, and it's certainly a lot cheaper than calling me. I'll tell you that. So definitely would invite everybody to come on down. Are there any more questions down in the Q&A? Neal, I want to make sure that we can answer a few things. I see where our participants are dropping off, which makes me sad, but that's okay. They'll miss the benefit of a couple of answers here.
Yes, we are going to share slides at the end. Hey, one of the questions, and I know there was, I think we may have answered it offline, are B2B leads that you buy from legitimate resources, B2B, and you think you've got a TSR exemption, but you're calling small, medium-sized businesses. What's a great strategy for that?
Oh, that's a great question. That's a great question. So the TCPA does not apply to business landlines. Yay. So you can call business landlines. It does apply to business cell phones though. So you better know if you're calling a cell phone or not. And of course, if it's a business number, truly a business number, then you don't have a DNC concern because the DNC rules only apply to residential numbers. Now, you've got to think about that last piece because many times folks will use a cell phone in particular for both as both a business number and a residential number. But just remember, if you're calling business landlines, you've got pretty good latitude. The only things that you really need to be concerned about are tying up more than one line of the business at the same time. That's one of these restrictions of the TCPA that people don't talk about that much. But people often get confused because they think, oh, the TCPA doesn't apply at all to business phones. That's not true, but it only applies to business cell phones. And the DNC doesn't apply to business phones. But you have to keep in mind that just because you're trying to call a business cell phone, maybe even about a business product, that you still might be calling a residential cell phone. And it is not your purpose of calling, it's not the product that you're selling, it's the use of the cell phone by the call recipient that determines whether or not the DNC applies.
There's interesting last question just popped up. I'll read it out to the crowd here. How do you validate a lead and consent when a vendor does not provide, some sort of trusted ID, active prospect sort of thing?
Well, you go back in time and you don't work with that vendor. Very simple. No, I mean, look, how do you prove it? Well, as a litigator, outside counsel, I can tell you that cases turn on evidence. They turn on admissible evidence that's properly authenticatable. That is to say, if you don't have in your system a record of exactly what happened that you can prove using your own witnesses exactly what happened, then you're relying on somebody else. And if you're relying on somebody else, then you need to subpoena them, depose them, and get evidence from them regarding what happened on their website that constitutes express written consent. And you need to do it in a way that will be admissible. And you got to have a pretty smart lawyer to make sure that that's done right. If you can't do that, or if they won't participate, or if they've disappeared, well, then you can't prove consent. And that's what this whole thing is about. Making sure you know who you're working with, making sure they're not fly-by-night. They're not going to just disappear on you, because you as the seller, in many instances, are going to be left holding that bag. So I don't know what to tell you. Go back.
And you have to prove that they provided consent. They don't have to disprove it. You have to affirmatively approve it. One note on calling business landlines, one thing to be careful for is sometimes it's difficult to make sure it's really a business line, just like with business cell phones. So there are a lot of people, it's becoming more and more common, especially during the pandemic when people are home anyway, more people have lost their jobs, where somebody might have an Etsy shop or some other like single member LLC that has a business name. Maybe it's even just a DBA, not even an LLC, but a business name, but it's really just their kitchen phone. And it's really just them on their kitchen table in their free time. Might be difficult to establish that that's actually a business line rather than a residential line. So be careful about that.
So would you feel comfortable, attorneys on the call, let's talk about B2B, running, let's say, business line verify. So in other words, that's a data product, right? And we can run it and it verifies whether Verizon, AT&T says that number is a commercial account, not a residential. Do you think that adds water to it versus some other methodology of trusted, authority?
Well, look, if this is a DNC.com product, I'm sure it's fantastic. But in truth, I don't know anything about that. So as with any vendor solution, you always have to kick tires and make sure you know what you're getting. But if there is a provable way to demonstrate that a number is a business commercial line, obviously any data point is helpful, and you want all the protection you can get. Now, that being said, again, if you're making outbound phone calls to anybody in America, be they landlines, residential lines, commercial lines, or cell phones, you're in a highly regulated area with a bounty on your head and a crosshair right on your back. So just think about what you're doing. I'm not telling you not to do it. I'm just saying, make sure you understand what the risks are and avail yourself of every product or solution that's out there to protect yourself, while recognizing that nothing is ever foolproof. And there's always an element of risk. And it's just a matter of how much risk you want to take on based upon how much benefit you hope to gain.
Let me throw in sort of one sort of final question, I guess. We've had a lot of questions about 10 DLC, which is the texting industry is moving from short code to long code. One thing is, I just want to state, as far as the federal government goes, a call and a text are the same thing, okay? So I get a dozen calls a day. I'm not calling anybody, I'm texting. Okay, that's great. And so I think so you have to follow some of the rules that we just talked about today. Consent, whether you're calling or sending a text, correct? And then the next part of most of these questions are really about call deliverability, kind of issues, but that's a whole different class.
The lawsuit's coming, folks. I'm telling you, man, there is a storm a-coming. There is a storm a-coming. These deliverability restrictions, I don't know where they come from. I don't know how long they're going to last. This new AMG Capital case really kind of demonstrated that in a 9-0 opinion, the Supreme Court is not going to let agencies kind of do things without statutory authority. And when you look at the default call blocking rules from 2019, I don't know where statutory authority was. And as 10 DLC gets rolled out, and as the carriers become more aggressive, might be too strong a phrase, but more comprehensive in terms of who gets to talk and who doesn't, and issuing trust scores and the like. And it's just a matter of time before all that stuff gets tested. So I'm going to be an eager watcher like everybody else, but yeah, deliverability is a big deal right now. And I'm happy to chat with anybody about 10 DLC and what you can do. And I'm liaising with a bunch of trades, and it's an interesting time to be alive as a telecom lawyer. I'll say that.
Cool. I think with that, let's, hey, Brian, just throw up the slide on the Masterclass workshop for everybody before we sort of exit out here. Just a reminder, going to get a big discount exclusive just to our Masterclass attendees. This is a great event. It's in Florida. Eric's there. Hopefully Daniel, hopefully Puja will be down there. You get a chance to meet and discuss and really dive into the issues that you're trying to solve. Look forward to meeting you there. Hey guys, I want to thank you again. Outstanding masterclass for those of us on it. I'll try to circle back to the audience, make sure you got your questions answered. Let's go around the room. Final comments, Puja?
Nope. Take this stuff seriously. Check out TCPAWorld, and if you're an in-house lawyer or a compliance person, keep all the points we discussed today in the back of your pocket.
That's awesome. Daniel?
See you at the bar in February or December.
December, yeah. Oh, first round is on somebody. And of course, Eric?
Yeah, no, I got nothing. We had a really nice discussion today. See you in December. I'm telling you, folks, get out there. It is worth it. Tell a friend, and it's going to sell out. So get there quick. I'm going to make them expand the attendee list, because we're going to end up with a lot of people there. But you don't want to be left out. I'm serious. It's my favorite event of the year. It's really cool.
Hey, as always, I want to thank everybody. Hey, on this, feel free to reach out to me if you have follow-up questions. I'll make sure they get to our panel, nkent@dnc.com. We're here to help. We're here to help you stay on the profitable side of business. So anyway, hey, everybody, have a great day. Great Cinco de Mayo, I guess. Let's go after that. Take care. Have a good one.